Thank you. You may be seated. We're here this morning in the case of Berger versus the Arizona Board of Executive Clemency. This is the time set for oral argument. Each side will have 20 minutes. Counsel for appellants responsible for reserving any time that you might like to have for rebuttal. These proceedings are being audio and video recorded, so we would ask that you identify yourself and your client when you approach the podium for the first time. We have read the briefs in this matter in the record. We've conferenced the case this morning. And with that, counsel, you may proceed.
Thank you, Your Honor. May it please the court and counsel, Herb Eli, attorney for the appellant Morton Berger. If I may, on a personal note, after many years of practice in the state of Arizona, I still consider it a singular privilege and honor to practice law, and particularly before this honorable court. Your Honor, respectfully, this is a case of a state government not following the criteria, the statutes, the mandate that it is governed by. The Clemency Board not only failed to follow this particular statute in this case, underlying, as this court knows, is a criminal case, and in considering whether they would recommend to the governor for commutation, their consideration is based upon the particular statute 31402C2 that states you consider whether the sentence is excessive by looking at his record and determining, in effect, whether or not he's going to conform with the law if and when commutation is granted. The law is picture clear from the cases that we cited and from the U.S. Supreme Court that constitutional rights, due process rights, govern this particular situation. It is not sufficient to say, well, he was given a hearing, but then the governmental agency has to follow the precepts that we just talked about. And in considering the excessiveness of the sentence in light of the factors that we have outlined and that the statute has outlined, that we have to consider that sentence in contemporary terms. Again, not only did the board fail to do this, but the board went back to his plea agreement 15 years ago. In this sense, not only was it a violation of them not to follow the statutes that govern, but it was a violation of due process, and it was a violation of due process a fortiori, because they based their decision essentially and virtually totally on the basis of whether or not he should have taken or not taken in that debate a constitutional right that he had to take or not to take a plea agreement.
Counsel, I read the proceedings as your client's witness brought up the issue of other similarly situated defendants or other people who'd committed similar crimes were receiving had received lesser sentences. And it seems to me the discussion of the plea agreement was in that context, that the response to they have a shorter sentence, but they pled guilty, and that explains why their sentence is different than your client's sentence. Am I misconstruing what happened with, I believe it was, the witness was Mr. Ash, was explaining that there were shorter sentences. Is that the correct context?
It is a correct context of one of our witnesses who suggested that. But that's not to say that what flows from that is that these members of this board, as opposed, by the way, to the first phase of this, in which the board unanimously recommended, as you are aware, finding the sentence excessive and meeting the statutory requirements, and making a recommendation of commutation to the governor. In this particular case, what this board did is not just peripherally, for a variety of reasons, they based their decision on that plea agreement. We had never contended that. That has never been our contention. It may very well be that one witness, Mr. Ash, suggested something to the effect of a plea agreement, but that does not give the board the right to determine the basis of their decision. And they did it, when you look at the record, they did it.
The strongest statement that you have by a board member that suggests that they were basing their denial on the fact that your client chose not to plead guilty.
Yes. And I say yes, but
can you point to particular statements by board members that you think highlight that they improperly based their decision on the plea?
Well,
his failure to take a plea.
Yeah. Yes. For example, when at the conclusion of the board procedures and everything that we had before that board, Chairman Wright, who you will see really essentially had no opinion whatsoever on this, he said, "What do you guys want to do here?" And because there was so much talk about the plea agreement, and Your Honor, to answer your question, on page 67, Quinones, excuse me if I mispronounced his name, says, "I'm concerned about the plea that wasn't taken." And then that's just one as an example. I mean, if respectfully, if you read this evidence, as I know you have, you cannot respectfully conclude that they based their decision other than on the plea agreement, totally outside, on nothing else. And what's important for me to emphasize to the court is that they had no evidence. What they quote in their briefs, how Miss Jones, the county attorney, said this, that, and the other thing, rhetoric. They had a right to have evidence to our psychologist, for example, renowned psychologist Dr. Simpson, who said that he had absolutely, or I should really say virtually, no chance of recidivism. And the regret, and at the risk of being slightly hyperbolic, this man's record, that's what should have been reviewed, that this man's record is unparalleled in the prison system, not only of what he has done to reform himself, but what he has done for other prisoners. And again, there is absolutely not a scintilla of evidence. And so, Your Honor, respectfully...
Are you suggesting that the state has to put on some type of evidence beyond even the facts and circumstances of the offense? Isn't that something that the board can consider? And then it's a very discretionary call on the part of the board, considering certainly the good points that you've raised, and considering that in light of the crime and the sentence that was imposed, and struggling with how we get out of a discretionary call by the board under those circumstances.
Your Honor, I would answer that question that it would depend upon what evidence the petitioner brings. If the petitioner doesn't bring certain evidence, yes, then of course there's discretion, and we admit that there is discretion. We admit that. And under some circumstances, it may be that they don't have to present anything. But while on the one hand, I say that they should have presented something, that's not the nexus of our case. I mean, it is a factor of it, but it's the fact that they based their decision not on something within their discretion that they may have had in this case, but based it on something totally extraneous and something that is a clear violation of his constitutional rights. And what this case is really about is a government agency that doesn't follow constitutional rights by being mandated by the statutes that guide it. It's no less than outrageous to permit, if this court would permit, a state agency to do that, when, again, it is clear to me, and I think it's clear in the record, it's not important for me, but for the record, that his constitutional rights were violated because the court based its decision on the plea agreement, which we never have contended that they should do. We stated the contrary. And there's no, and that's what the record reveals.
But your argument is not that the board could not consider the plea agreement, correct?
Yes, it is, Your Honor.
They should never have considered the plea agreement, is that?
That is correct.
Okay.
That is our position.
But let me follow up with Judge Catani's question then. It seems that one of your witnesses sort of put that in play.
Well, Your Honor, the fact that one of the witnesses got up and talked about the plea agreement, we never made that argument that they could consider the plea agreement. There was a witness that stated, among other things, that he talked about the plea agreement, but that was never our position. I mean, Judge, frankly, our position, I'm repeating myself, but our position is yes, that it should never have been considered. That is correct. And for them to take what one witness says about a plea agreement and then make that part of their decision so that they can presumably try to justify themselves is totally unfair and wrong.
Let me ask you a hypothetical, right? So it's the same factual record, the same evidence and arguments that are in the record are presented. But when they get to deliberation, instead of doing what they do, the conversation that they have, the board says, I have individually, I've considered this and I vote to deny. That's it.
I've considered this, I'm sorry, Your Honor.
And I vote to deny the request. That's it. There's no robust conversation. There's no mention of plea. It is then kind of a black box as to what they looked at. Would your argument be the same?
It would be much more difficult, Your Honor. I need to be frank with you, because if we did not have the evidence that they based their decision on the plea agreement of 15 years ago, we would have had a much tougher time, and we would not be able to pursue the same argument. That is the frank answer to your inquiry.
I appreciate that.
Thank you. I will wait for any rebuttal that I still have an opportunity. Thank you.
Thank you.
May it please the Court, my name is Kelly Gibson. I'm an Assistant Attorney General with the Attorney General's Office, and I represent the Arizona Board of Executive Clemency. I also want to advise the Court that sitting in the gallery is Ms. Catherine Blades, who is the Executive Director of the Arizona Board of Executive Clemency. The issue before the Court today is whether or not the Superior Court erred in making a determination that Mr. Berger had received due process in his commutation hearing and that the Board had acted within its scope of authority. Commutation is a matter of grace. It is not a constitutional right. Individuals who are lawfully sentenced do not have a constitutional right to have their sentences commuted or reduced. no liberty interest attaches to commutation. And that's why the Arizona case law on this says that due process is simply notice of the hearing and an opportunity to be heard. Mr. Berger concedes that he had notice of the hearing and that he had an opportunity to be heard. You have approximately 70 pages of transcript showing that he had an opportunity to be heard on the commutation. It's also important to note why Mr. Berger strenuously argues that this court has to look at the evidence or the lack of evidence. The court's judicial review is limited. It's limited to two things. Was Mr. Berger provided due process, and did the board act within the scope of its authority? And, Your Honors, the board did. The board provided due process, and it acted within its scope of authority. Its authority is under Arizona statute section 31402, which is they have the sole discretion to make a recommendation to the governor of whether or not someone's sentence should be commuted.
Counsel, if the board had said, based on the race of the defendant, say the defendant were Hispanic or some other race, we just think he would be a danger to the community and we're not going to recommend commutation. Would a defendant and a prisoner in that situation have a remedy?
Yes, Your Honor, and the remedy is the special action, and that's an unconstitutional, impermissible factor for the board to consider. But that's not what happened in this case at all, Your Honor. The board followed the statutory criteria in determining whether or not the sentence was excessive. And I think it's important to note that Mr. Berger conveniently left out the whole standard in this case. If you review the standard in 31402C2, it's whether or not there's clear and convincing evidence that the sentence is excessive given the nature of the offense. And I think that's significant that Mr. Berger left that out, because his whole argument is that the board should not consider what Mr. Berger did, all the victims of the case, the heinous acts that he committed, but rather only focus on what he did in prison. And the statute requires the board to look at both of those things, whether or not the sentence is excessive given the nature of the offense. Mr. Berger argues that the board denied him because he didn't accept a plea agreement. There are no statements in the record that supports that. And Judge Cantani, as you mentioned, it was Mr. Berger himself who brought up the issue of the plea agreement, and not just through Mr. Ash, but through the other witnesses. Ms. Berger told the board that he was the poster child of these type of sentences, that they really went after him, that he was somehow singled out. Mr. Ash submitted documentation, and this was Mr. Berger's primary argument on why the sentence was excessive, was look at all these people. I mean, all these people only got like 21 years, and poor Mr. Berger got 200 years. And then board member Johnson looked at him and said, but wait a second, Mr. Ash, you're comparing essentially apples and oranges. You're comparing all these individuals who chose to accept a plea deal to someone who took it to trial, and after being convicted, the court had no choice but to impose the mandatory sentences. The record is replete with instances where Mr. Johnson refers to the documentation that Mr. Ash gave to him. And in the discussion, Mr. Johnson said, I reviewed the documentation and I can't find that it's excessive. And I can't find that it's excessive based on your argument that these people received a less sentence than Mr. Berger, so therefore it is excessive.
Counsel, would it be appropriate for the Board of Clemency to reject a petition solely on the basis of a plea offer that was not accepted?
It would not be appropriate, Your Honor.
Okay. What then is the proper role of a plea offer that's not accepted in a petition for clemency?
Your Honor, I don't know if I could define whether or not there is a proper role for it. I think you have to look at the facts in this case, and it was used to try to prove that it was excessive. And so that is why there is a discussion. And
I understand, and we have the benefit as readers, not as participants, of the transcript from the hearing here to understand how, at least in part, the plea offer that was not accepted was considered. But sort of looking at it more globally, more hypothetically, if you will, Should information about a plea that wasn't accepted be received in hearings like this?
Your Honor, I think that's a difficult answer, a difficult question to answer, because I think lots of times the prosecutors, when they provide the background of the case, they often put that in there. So again, I think it can be part of the discussion. I don't think that is impermissible. The idea is whether or not the board bases its finding on the statutory criteria and on excessiveness. And again, Mr. Berger's not arguing that it was just mentioned. He's arguing that the board declined a recommendation to the governor solely on the basis that they rejected the plea agreement. I can give you an example of lots of times there's a discussion when people accept plea agreements and they come to ask for commutation, and there is a dialogue on, you accepted the plea agreement, you knew what you were getting when you accepted it, why now are you arguing that it's excessive when you agreed to that plea agreement? So I think discussion is appropriate. I think what Mr. Berger is arguing, and I agree with the argument, I don't think it happened in this case, which is you can't deny a recommendation to commutation based on someone's exercise of their constitutional rights to go to the trial.
Counsel, it seems to me that discussion of a plea would be, if I were representing someone who had been offered a plea, I would want to offer that as evidence that at some point the prosecutor felt that this was a reasonable sentence that could be imposed. So it seems to me it would be evidence, as someone representing an inmate, that I would want to get in the record. It seems like it is relevant to the discussions, at least to say at some point the prosecution felt this would have been a reasonable sentence, and you should consider that as part of your deliberations. Is that fair?
Yes, Your Honor, and I would agree with you. Again, it's hard in the abstract to talk about in what context does the plea come in. Again, if it's solely, hey, he rejected a plea agreement, don't give him a commutation, I think that's improper. But in the context of what you're saying, absolutely it comes in. And I don't think the board should be limited to what Mr. Berger is suggesting in this case, that they're limited to. His argument appears to be just that they look at the composite sentence. So his whole argument is, hey, it's 200 years. That's a lot. That wasn't his argument before the board. The argument before the board is, Mr. Berger was singled out. He got an excessive sentence. Look at all of these people. But now here today, he seems to argue that the board is limited to that. He also argues quite a bit when he attempts to tell this court that they have to look at the sufficiency of the evidence, that the prosecutor didn't present any evidence, and that anything the prosecutor said was inappropriate, and that is just wrong. Again, as I mentioned, the standard is whether or not the sentence is excessive given the nature of the offense. And the prosecutor had information on the nature of the offense. And again, this goes to whether or not the sentence was excessive because she spelled out aggravating factors. Mr. Berger had 15 victims. Most of those victims were under 10 years of age. And he didn't just possess child porn. He possessed graphic videos that tortured small children, that included bondage. And he not just had one, he collected whole series of sets. I think it's equally telling when the prosecutor said they dismissed 10 counts because the videos in those counts were so horrific, they could not risk traumatizing the jury with the nature and the content of those videos. That information goes to the nature of offense. That information goes to whether or not the sentence was excessive. And that is appropriate discussion. That's appropriate information and evidence for the board to consider, Your Honors.
Counsel, if the prosecutor offers examples of other defendants who received similar sentences or longer sentences, is there anything improper if the prosecutor includes defendants who maybe did something beyond possessing that involved touching or other? Was that raised as part of the discussion before the board, or I noticed that in the briefing, but I don't know to what extent that was offered, that these are similar sentences that other people received that may have involved more serious conduct.
Well, first of all, I would argue that Mr. Berger waived that argument, that issue regarding the prosecutor's statements regarding the sentences was not addressed in the Superior Court, was not addressed in his opening brief, and was only mentioned in his reply brief. But regardless, I think that what's important about that information is it was to refute Mr. Berger's assertion that he was somehow singled out. I think if you look at Board Member Johnson's statements, he indicates that those sentences were similar, or maybe they were even worse than the conduct that Mr. Berger had done, but they were, again, sentences well over 100 years. So I think it was relevant in the term that Mr. Berger wasn't an outlier, that no one else has received this type of sentence, but other people had also received similar sentences, Your Honor. So getting briefly to Mr. Berger's argument that the board could not consider the plea agreement or the prosecutor's statements at all, again, I think my previous argument has demonstrated that both those issues were substantially related to the criteria under 31402 C2. Your Honors, the board gave Mr. Berger due process. He had notice. He had an opportunity to be heard. The board considered all of the evidence outside of what Mr. Berger just wants the board to consider, which was his record in prison. But they considered all of the evidence, and they made a determination that the sentence was not excessive. That is part of the statutory criteria. Mr. Berger argued that they didn't address the second prong, which is whether or not he would conform his conduct to the requirements of the law, but the board is required to find both. That's excessive and that he's likely to not reoffend when he's on the outside. Both Board Member Johnson and Board Member Quiones found that the sentence wasn't excessive, so there was no need for them to get to the second part of the standard. However, during the discussion, Board Member Johnson, they did recognize the nature of the offense, and they did express concern. Mr. Johnson, on at least 2 occasions, said, there's a dark side to Mr. Berger. There's a dark side that no one knew about what he was doing until this was exposed. And Dr. Wright also addressed Mr. Berger on whether or not he had received sex offender treatment while in custody, and noted to Mr. Berger how important it was to get that treatment given that the record he had. So I would request that this court affirm the Superior Court's findings that the board provided due process and that it acted within its scope of authority. Thank you.
May it please the court, as a point in this matter, it is of interest, even though this is a de novo appeal from Judge Reinstein's ruling. He said in his ruling, clearly, he used the word, I think, certainly, this sentence was excessive for this man. That's what he says in so many words. Then he goes on to say, but it's legal. And so he used, on the one hand, he said what we are suggesting. On the other hand, he used the wrong test to determine whether the board violated his constitutional rights. But I do want to make that point because, on the one hand, we are not suggesting to this court that this was a minor case 15 years ago, even though we have throughout the proceedings before this stated that this was cruel and unusual punishment. But that's not the issue before this court. The issue before this court is to view this sentence in terms of the statute on a contemporary basis. Counsel makes the point that we're saying...
I'm sorry, counsel, what do you mean on a contemporary basis? I'm not understanding that.
On his record as a prisoner. On that record, okay, is what I'm saying, Your Honor, if I didn't make myself clear. And, Your Honors, what I want to say to this court, quite frankly, is that if this court finds, on the one hand, that was not the basis of the plea agreement, had nothing to do with anything, then we as petitioners have a difficult case. But it's quite the opposite. I respectfully state to this court that this court cannot have a view of the record and find anything but that this board based its decision totally on the fact that he did not accept a plea agreement. And no witness that we presented that ever said that that should be done or is it in any manner inconsistent with our position. I just want to say finally, counsel for the state makes the states that, well, really all he's entitled to is a hearing, then that satisfies due process. No, that's the beginning of the due process, because the due process requires that he that he be given substantive due process, procedural due process, and that the statute is criteria is followed, and that they didn't do. What it comes down to, Your Honor, if I understand, in answer to one of the judge's questions to counsel, if they based their decision, if the board based their decision on the plea agreement, when all of the argument between us is finished, that I think she says, yeah, that would be wrong. Then that would not be proper for the court, for the board to do that. And that's precisely what happened in this case. And there is respectfully no other reading of the record. Thank you.
Thank you both for your argument. We will take this matter under advisement and issue a decision in due course. And with that, we'll take a recess before the next case.
Thank you, counsel.